The basketball coaching contract in Eckles versus Sharman contained two unenforceable provisions. No party seriously disputed that. But could those provisions be severed from the rest of the contract to save it, or were they too essential? In the late 60s, William Sharman entered into a 7-year coaching contract with the Los Angeles Stars, a member of the newly formed American Basketball Association. The contract, which was governed by California law, provided that Sharman would be given an option to purchase an ownership interest in the team at a price to be fixed in the future. The contract also provided that Sharman would participate in a pension plan, but offered no elaboration about the plan. Lastly, the contract contained a severability clause, which said that the unenforceability of one or more provisions would not affect the enforceability of any of the other provisions. 2 years later, the Stars were sold to a Colorado company, Mountain States Sports. The sale agreement provided that Mountain States would only be compelled to assume the Sharman contract if Sharman confirmed that he would transfer to a new city with the team. The team ultimately moved to Salt Lake City and became the Utah Stars, and Sharman followed without anything further in writing. For about 15 months after that, Sharman and Mountain States negotiated over the ownership option and pension provisions of his original contract, which were never discussed while the team was still in Los Angeles. When the parties failed to reach agreement, Sharman resigned from coaching the Utah Stars and signed a new contract with the Los Angeles Lakers. Mountain States sued Sharman for breach of contract in a Utah state trial court. It also sued Los Angeles Lakers owner California Sports and 2 individuals for tortiously inducing Sharman's breach of contract. The case was then removed to Utah's federal district court. After Mountain States presented its case at trial, the district court directed a verdict against Sharman on the issue of liability. The case then went to the jury to consider the damages recoverable from him, the liability of the other defendants, and the damages recoverable from them. The jury ultimately found in favor of the 2 individuals, but returned verdicts against Sharman and California Sports in the amounts of $250,000 and $175,000, respectively. Sharman and California Sports appealed to the 10th Circuit. After their appeals were filed, Mountain States went bankrupt, and the bankruptcy trustee, R.T. Eckles, was substituted as the named party to the proceedings.